waiting for the other two commissioners who are registered. So we have a quorum.
That sounds good.
Can you hear me now?
Yes, I can hear you, Kate.
Okay, I'm just going to leave it unmuted for now.
Okay, and Kate, I sent you the registration list, so you have before you who is registered to testify.
Oh, great. Okay, let me pull that up. Did you send? Okay, I got it.
Yeah, I sent it to both your emails from the WC planning.
Got it. Okay, let me pull that up.
Hey, Daniel, this is Steve McCoy. I emailed you a handout just a few minutes ago. Would you please distribute that to the planning commission?
Yeah, give me 1 second.
Great, thank you. Here's that handout.
We're just waiting on Russ.
Okay, and let's see, in terms of confirming participants, the list of participants and meeting documents, I'm trying to manage 3 screens, the registration report and the,
Correct.
are those the folks who are, the list of participants is on that registration report?
Correct.
Got it. Okay.
Steve, I haven't received the email yet.
Interesting. Oh, it's sitting in my outbox.
And there's Russ. Go ahead, Chair and Daniel, and hit record. And since we have so many folks testifying, I'm going to leave us unmuted, but if you can just reduce any crosstalk because it is recorded and it becomes difficult for us when we're trying to review.
Kelly, I have a question. This does say that this is about revisions or corrections to the September 7th meeting. And we are not doing the September 20th meeting. Should that be 20? I'm looking at the script and it says September 7th, and I believe it was the 20th or.
It was the 20th.
Okay, so this would be 20. Okay.
Correct.
All right, very good. Thank you.
Have you had any luck, Steve?
No, I'm not. It's sitting in my outbox. I'm trying something else.
And Chair, we do have a quorum now, so you're good to start the meeting whenever you're ready.
Oh, very good. Okay, that's great. Okay, we will bring the meeting to order. Welcome commissioners, staff, and public to the meeting. Wasco County is hosting a hybrid in-person and virtual meeting. By the way, this is Kate Willis. I'm chair. I'm bringing everyone together. Staff has prepared a public participation guide on how to use Zoom that is posted on the Planning Commission's agenda and meetings and remote meetings web pages. This hearing is also available to live stream via YouTube and on the Wasco County website. Director, could you please call roll?
Chair Willis?
Yes, can you hear me?
Yes. Chair Hargrave?
Oh,
Sorry,
Hi,
Commissioner
I'm-
Hargrave,
I'm present.
Commissioner Swift,
Here.
Commissioner McIntyre.
here.
And for staff, I'm Planning Director Kelly Housley Glover, and we have also with us Daniel,
Daniel Doherty, Senior Planner.
and also in attendance is Administrative Staff Krista Harris.
Thank you, Director. Are we ready to move to important announcements?
Yes.
Great. This meeting is being recorded and will be publicly available. All participants must mute themselves unless they're speaking. Lines providing feedback while not speaking will be muted to ensure others can hear. Only you can unmute yourself using the mic icon. If you are participating by phone, unmute yourself by dialing *6. Participants behaving inappropriately will be promptly removed from the meeting. The chair will specifically invite participants for public comment at the appropriate times, so please be patient and wait to be called on. Please refrain from using the chat feature unless directed by the chair. It will distract from the intended flow of the hearing procedures. We're moving now to public comment on items not listed on the agenda. We'll ask that speakers please limit their testimony to 3 minutes. Invite the public. I'd like to make sure that you unmute your mic and share any comments that you have for items not listed on the agenda. Does the commission have any revisions or corrections of the September 20, 2021 meeting minutes? Hearing none, may I hear a motion to approve the minutes from the September 20th, 2021 meeting?
Chair, I have a question. Is it September 2022?
Yes, my apologies. Thank you. Yes, September 20th, 2022. Thank you. Thank you, Daniel Doherty. May I hear a motion for the approval of these minutes?
Chair, I think one of the difficulties may be that commissioners that were in attendance on the 20th aren't present.
In that situation, Director, do we then defer to the next meeting that we're having to approve these minutes?
Yes, we can do that, Chair. Thank you.
Okay, great. We'll
Well,
defer
I
until
mean,
the next meeting.
So I was present and I can make the motion, but do we have enough who were present to proceed with the motion?
Commissioner Hargrave, no, we do not. The other
Okay.
3 commissioners in attendance were not in attendance on the 20th.
Okay, we'll do that later then.
Great. Thank you, Commissioner Hargrave. Hearing that we don't have a quorum at this time, then I would like to, just for the record, state that we will return to the minutes of September 20th, 2022 at a future meeting, the next meeting, and we will have comments and a motion at that time. Moving on to the next item, the public hearing is now open for the purpose of the Planning Commission's consideration for the land use appeal for the file number 921-21-000-178-PLNG. A national scenic area review to construct the following. 1, 33,480 total square feet, which is 99 feet long, 23-43 feet wide, and 15 feet high dwelling. 1,500 total square foot accessory dwelling building that is 60 feet long, 30 by 30 and 20 feet wide and 15 feet high. And third, a gravel driveway of 390 feet long by 12 feet wide. The subject parcel lies in the National Scenic Area boundary and is located approximately 0.35 miles east of the State Road and Dell Road intersection, approximately 3.2 miles southeast of the city of Mosier, Oregon, more specifically described as map and tax lot 2N12 East 91300, account 1688. The subject parcel is within the RR residential, rural residential zoning, GMA and SMA zone. The criteria for approval of the land use decision includes the following chapters within the National Scenic Area Land Use and Development Ordinance for Wasco County, which is part of the LUDO. Chapter 2, Development Approval Procedures, Section 2.150, Appeal from Decision of the Director. Chapter 3, Basic Provisions, Section 3.160, RR, Rural Residential Zone, GMA and SMA. Chapter 4, Supplemental Provisions, Sections 4.040, Off-Street Parking, Off-Street Parking. Chapter 11, Fire Safety Standards, and Chapter 14, Scenic Area Review. The proposed development must comply with applicable provisions contained in the management plan for the Columbia River Gorge National Scenic Area. Generally, unless otherwise noted, if a request is found to be consistent with the NSA, which is the National Scenic Area LUDO, Land Use Development Ordinance, it is considered consistent with the management plan. We're moving now to party recognition. Anyone can speak for or against the proposal today. However, only those having party status will be able to appeal a decision reached by this commission. If you want party status, please say so at the beginning of your testimony. Automatic standing is provided to the following parties. A, the applicant and all owners or contract purchasers of record as shown in the files of the Wasco County Assessor's Office of the property which is the subject of the application. B, all property owners of record as provided in A above or within the notification area as described in section 2.080A2 of the property which is the subject of the application. C, any affected unit of local government or public district or state or federal agency. D, any other person or his representative who is specifically, personally, or adversely affected in the subject matter as determined by the approving authority. And E, any person who is heard by the Planning Commission orally or in writing before the close of the hearing. The procedure I would like to follow tonight is the Planning Department staff will present their report. The appellant will then have the opportunity to testify. The commission will then call upon anyone who wishes to testify in favor of or in opposition to the proposed use. The appellant will then have the opportunity to rebut. Once there is no further testimony from parties who have not testified, the commission will then decide if it is appropriate to close the public hearing. Once the hearing is closed and the commission may ask questions, deliberate, and then vote on the decision. The rules of evidence are as follows. No person shall present irrelevant, immaterial, or unduly repetitious testimony or evidence. Evidence received shall be of the quality that reasonable persons rely upon in the conduct of their daily affairs. Testimony and evidence must be directed toward the criteria applicable to the subject hearing. Failure to raise an issue accompanied by statement or evidence sufficient to afford the commission and parties an opportunity to respond to the issue precludes further appeal based on that issue. Any party of record may request that the record remain open for at least 7 days prior to the conclusion of the initial evidentiary hearing. Failure of persons to participate in the public hearing, either orally or in writing, precludes that person's right of appeal to the Board of Commissioners. Written testimony submitted prior to the hearing constitutes participation in the hearing. Does any commission member wish to disqualify themselves for any personal or financial interest in this matter? If so, please unmute yourself to state yes or no. Hearing none, I'm going to move to the next question. Does any commission member wish to report any significant ex parte or pre-hearing contacts? Hearing none, I'll move to the next question. Does any member of the audience wish to challenge the right of any commission member to hear this matter? If so, please unmute yourself. Hearing none, I'll move to the next question. Is there any member of the audience who wishes to question the jurisdiction of this body to act on behalf of Wasco County in this matter? If so, please unmute yourself. Okay, hearing none, we will move to the staff presentation. At this time, I'm asking all participants to please mute yourself and hold questions until the end of the staff's presentation. I will also mute myself while we're listening to the presentation. And then I'd like now to the staff to begin your presentation.
Thank you, Chair Willis. Good afternoon, everyone, commissioners. Daniel Doherty, Senior Planner, Wasco County Planning Department for the record. Give me 1 second, let me get the presentation ready. All right. All right, today I will be presenting the findings and addressing the issues that were submitted on appeal and providing staff recommendations for this specific application. Go ahead and jump into the agenda. We're going to go ahead and talk a little bit about the request and background, and then we'll dive into the location, zone, talk a little bit about the surrounding development, vegetation, and slope. Then we'll move into the applicable KVAs or key viewing areas, and also talk briefly about important terms. And then we'll jump into really the meat of this, which is the reasons for appeal or assignments of error. There's a lot of maps and a lot of slides, so if you need me to slow down or back up because you want to take a look at a specific slide, just let me know. You'll also notice this superscript RC on some slides. This is for record corrections that I'll call out for acknowledged corrections where staff has found slight discrepancies that will be corrected in the final staff report. There's a lot of data and analysis as well. I also want to note that staff has altered some conditions of approval from the staff report, and I'll go ahead and point those out. Further, to this date, staff has received no additional information from either the appellant or the applicant that would alter these findings and recommended conclusions or recommended conditions of approval. Mr. McCoy did submit a document that I have actually been able to forward to the Planning Commission that may be relevant or is relevant after this presentation. So, but I haven't actually viewed that document yet, so. So as noted earlier, the request is for a 3,480 square foot dwelling, 1,500 square foot accessory building, and 390 feet of gravel driveway. The background, the request or the underlying request was approved with conditions by administrative action on May 5th, 2022. And we properly received a appeal on May 20th, 2022. So as the vicinity and zoning map point out, the subject parcel is approximately 9.53 acres in size. It's approximately 3 miles southeast of the city of Mosier and 6 miles northwest of the city of the Dalles. The parcel falls within the RR Rural Residential Zone General Management Area. The purpose of the zone, quote, residential development may locate outside urban areas so long as it does not adversely affect the scenic, cultural, natural, and recreation resources, end quote. So essentially the request meets the purpose of the zone and is allowed so long as it doesn't adversely impact those earlier mentioned resources. And as you can see on the map, parcels located to the east, west, and south are within the R10 RR Rural Residential Zone. Parcels located to the north are within the A240 or A2 Small Scale Agricultural Zone. And parcels located further to the east are within the A1 160 or A1 Large Scale Agricultural Zone. So this is kind of a wider development map that was created for this specific presentation. The green boxes represent all of the Wasco County registered addresses. There are 26 addresses in this image. Best available data provides that the development primarily consists of single-family dwellings along with accessory structures. The neighboring parcels to the west and northwest are heavily forested. There are few, if any, active perennial farms and orchards in the area. And again, this is just best available data. So this is a recent image of the subject parcel. As you can see, it's undeveloped. The parcel is primarily vegetated with natural grass, but does contain a grove of approximately 1+ acres of medium to large oak trees located on the northwest portion of the property. This is just a wider angle of the overall area. As you can see, the vegetation mimics the subject parcel with a lot of natural grass cover as well as dense forest areas of both deciduous and conifer tree growth. This is a picture of the oak forest on the subject parcel taken by staff during a site visit. Trees range, and this comes from at the application materials, trees range in size with many exceeding 30 feet and up to 50 feet in height. The applicant provides that some of the trees are approximately 300 to 400 years old. This is just illustrating the slope. Slopes are 6 to 8% throughout the parcel, with the northwestern corner of the lot sloping into a kind of a small depression. So this is my first record correction. The staff report provides that the development site is topographically visible from 3 key viewing areas on pages 26, 33, and 55. So this is a scrivener's error and will be corrected to include 5 key viewing areas. So the identified KVAs are Rowena, Washington State Route 14, the historic Columbia River Highway or Highway 30, Interstate 84, and the Columbia River. These KVAs are identified from data obtained from the Columbia River Gorge Commission GIS layer Scene Areas Composite. The layer identifies topographically visible KVAs. However, just because the layer provides that the parcel is topographically visible does not necessarily mean that either the development or the parcel is actually visible from that particular KVA. So we're going to move into important terms, and I won't read these verbatim for you, but essentially adversely affect means that there's a reasonable likelihood of more than moderate adverse consequence. The determination of which is based on the action, the proposed action, the intensity of the proposed action, the relationship between a proposed action and other similar actions, and proved mitigation measures. And these are all found within the management plan, as well as the LUDO. Cumulative effect just means the combined effects of 2 or more activities. Cumulative effects can result from individually minor but collectively significant actions taking place over a period of time. Mitigation. So mitigation can mean avoiding the impact altogether, minimizing impacts by limiting the degree of the impact or the action, rectifying the impact, or reducing or eliminating the impact altogether. And this is commonly why we have conditions of approval. So the applicable standard for this specific request is visually subordinate. In this case, it is visually subordinate is a description of the relative visibility of a structure or use where the structure or use does not noticeably contrast with the surrounding landscape as viewed from a specified vantage point. So a key viewing area, or generally a key viewing area, as opposed to structures that are fully screened. Structures that are visually subordinate may be partially visible. They are not visually dominant in relation to their surroundings. And then finally, substantial evidence. This comes out of LUBA, a Land Use Board of Appeals case law. And substantial evidence is a evidence a reasonable person would rely on in reaching a decision. It's pretty straightforward. All right, so the first issue on appeal provides, quote, the landscaping plan in the application does not accurately or adequately identify the locations and species of all existing and proposed trees on the parcel, which violates NSA LUDO subsection 14020D and makes it impossible to determine through substantial evidence that the scenic resource protection standards will be met, end quote. And I've also provided the applicable criteria. So straightforward, the criteria requires that the landscaping plan, which can be combined with the site plan, provide the location, height, and species of existing trees and vegetation, existing vegetation that will be removed, illustrate vegetation for the proposed development, topographically visible corridors, illustrate the location, height, and species of proposed trees and vegetation groupings. Subsections, and that's subsections D1 and 2, subsections D3 and 4 require that the plan illustrate fire safety fuel breaks and show the location of sprinkler systems or other irrigation, irrigated landscape. So the application submitted a site plan, landscaping plan. It was called Exhibit D, planting plan. And as you can see outlined in red is the location, height, and species of existing trees and vegetation, which include the 30 to 50 foot tall high oak trees to the northwest corner of the parcel, as well as a number of ponderosa pines that are identified. So outlined in yellow is the one ponderosa pine that's proposed to be removed. However, applicants have indicated that if it can be saved, it will be saved. Highlighted in green illustrates the proposed vegetation and topographically visible corridors, the proposed vegetation that will be planted to mitigate visibility from KVAs. And then the dashed blue line indicates the fire fuel break and irrigated landscape that's proposed as well. So based on the substantial evidence provided within the submitted site plan Exhibit D, staff finds that criteria of subsection 14020D has been met. Staff recommends the Wasco County Planning Commission dismiss this ground for appeal. Appeal grounds number 2, and I won't read this verbatim, but essentially the second ground of appeal provides that miscellaneous condition of approval number 2, which requires a replacement of Oregon white oak trees at a 3-to-1 ratio, is inconsistent, and that if oak is to be removed, it must be on the landscaping plan. Staff analysis provides that there's no Oregon white oak specifically to be removed that's called out within the application. Only one ponderosa pine will actually be removed. Miscellaneous condition number 2 in the original staff report was provided to try to ensure future protection of Oregon white oak trees on the property and was added primarily based on ODF&W's commentary. Specifically, District Wildlife Biologist Jeremy Thompson's January 14th, 2022 commentary, quote, ODF&W requests that to the greatest extent possible, no Oregon white oak should be removed as a part of this development. Oak is an important component to the habitat within the area proposed for development, end quote. However, upon further examination, staff has found no legal nexus for this condition and it is no longer being recommended. So based on staff's findings and the fact that miscellaneous condition number 2 is no longer being recommended, staff recommends the Wasco County Planning Commission dismiss this ground for appeal. Appeal grounds number 3 provides that, quote, the decision violates NSA Ludo subsection 14-100C because it does not ensure that the proposed new buildings will be compatible in size and overall mass with that of existing nearby buildings, end quote. The applicable criteria, section 14-100C provides that new buildings shall be compatible with the general scale, height, dimensions, and overall mass of existing nearby development. Expansion of existing development shall comply with this guideline to the maximum extent possible or practicable. So generally, staff examines regarding this criterion, staff examines the height, dimensions, and footprint of the requests, any submitted commentary if applicable, and then we examine 20 properties with development in the surrounding area. However, based on this specific ground for appeal, staff re-examined this criterion in greater detail. So application materials did provide some comments with regards to the design and overall size and scale of the structures. And again, I won't read these verbatim, but essentially, the application materials provided that structures are low-slung, single-story buildings, 15 and 15.5 feet in height, and that they are designed to emphasize low lines, primarily utilizing the oak forest backdrop to screen the development from Rowena/Tom McCall KVA. This is the elevations that were submitted of the dwelling. And again, the maximum height of the dwelling is 15 feet. So this is 15 to 35 feet shorter than many of the oak trees that make up the 1+ acre forest on the northwest corner of the subject parcel. This was the floor plan that was submitted of the dwelling. It's not a common rectangular or a square shaped structure. It's more of a Z-shaped structure. It's not 2 stories. And because of the dwelling shape, some of the areas are actually only 23 foot wide, or 23 feet wide. This is the elevation plan for the accessory building, 15.5 feet high. And the floor plan, the submitted floor plan, fairly standard garage area, art studio, trash enclosure, as well as a shop. Staff received several comments concerning this criterion. I won't read them verbatim, but I thought it important to provide the comments, at least in part. We received comments from Friends of the Columbia Gorge on January 7th, 2022, as well as John and Jennifer Coughlin on January 27th, 2022. And again, if you want to read these, they are in the staff report, and I will back up the slides. Mr. Herb Friedland submitted comments on April 7th, 2022. And Joe Maynard and Jesse Buckwalter submitted comments on April 20th, 2022, and updated their comments for today's hearing. The comments provided on the screen are actually the comments that were provided this morning when they submitted their updated comments. Okay. We'll go ahead and move forward. So in diving deeper into this criterion, staff broke down the requirement of the subsection. And I'll read the subsection again, 14100C. New buildings shall be compatible with the general scale, height, dimensions, and overall mass of existing nearby development. So based on the above, it is reasonable to conclude the following: that 1, new buildings must be capable of existing in harmony with the general scale of existing nearby development. The general scale, or the height, dimensions, and mass, means that analysis of nearby development includes the overall totality of development. That mass means the whole area occupied by a particular development, so structure or groupings of structures. And that nearby development is a subjective term and provides no clear definitive area of analysis. It gives no explicit objective distance for measurement and can be defined differently by different people. So in acquiring the analysis area, staff utilized the Wasco County GIS public notification tool and searched 750 feet out from the subject parcel's property lines. And this is commonly used and has been used since I started in 2018. Staff utilized 750 in this particular case because that is the state of Oregon and Wasco County's notification requirement and resource zones. And in this particular case, the parcels within the general area are large in contrast to properties within urban areas. And so, of course, this parcel is not within a resource zone, but 750 feet provided staff with a uniform distance that enabled a larger amount of properties to be included in this analysis area. And so plugging 750 feet in from the subject parcel's property lines, we came up with 19 properties total, 14 physically developed, but that did not get us our 20 that we commonly seek. So staff went out 1,500 feet and acquired 35 properties, 4 additional undeveloped properties, and 10 additional physically developed properties, for a total of 24 developed properties that were actually used in this analysis. So outlined in red is the breakdown of properties that were acquired from 750 feet out. Outlined in blue are all the additional properties that were examined at 1,500 feet out. Now, the GIS tool extracts information from the assessor's office and allows staff to acquire basic details of property development that includes structure square footage, how many floors or stories the structure is, and the year of recorded construction. Planning records were also utilized where available and when available, specifically for some of the newer developments. The years of property development range from the 1970s to 2021, but some data all the way back to 1940. I want to emphasize that the analysis of development did not include surrounding property curtilage. So like the areas surrounding the dwelling, surrounding the accessory structure. It didn't include patios, and it didn't include driveways and other space used that could be or is considered development. So the proposed single-story structures are in line with general height requirements of the zone, and overall dwellings within the study area are a mixture of single-story and two-story buildings, with single-story buildings beating out two-story buildings. There are 15 single-story buildings, or dwellings, I should say, or 62.5% of the developed area. The largest building in the analysis area is a dwelling at 3,743 square feet. The proposed dwelling is 263 square feet smaller than that dwelling. The proposed accessory structure or building is 1,180 square feet smaller than the largest accessory building in the area, which is 2,680 square feet. The average size of the 24 dwellings is 1,795 square feet. The total developed area of the 35 properties examined is 61,224 square feet. So this is very approximated. And again, it didn't take into account other types of development. It just roofed structures and information that we could get from the assessor's office. These stats are located also on page 24 of the staff report. So the combined footprint of proposed structures is 4,980 square feet. The subject parcel is 9.53 acres or 415,126 square feet. The footprint of proposed structures equals approximately 1.2% of the subject parcel. 17 of the developed properties, or 70.8%, have a development footprint of over 2,000 square feet. So that's 8 properties at 2,000 square feet, plus 7 properties at 3,000 square feet, plus 2 properties at 4,000 square feet or greater. And so this is my second opportunity to correct the record. The staff report on page 25 provided that 8 of the developed properties were 3,000 square feet or greater, but the correct number is 9. So that's 7 3,000 dwellings at 3,000 square feet up to 3,999 square feet, plus 2 dwellings that are 4,000 square feet or greater. And of course, there's 2 of the developed properties, or 8.3%, have a development footprint of over 4,000 square feet. And again, it's important to remember that this analysis doesn't incorporate, again, driveways, patios, yards, the parking areas, those kinds of things. That type of information is extremely difficult information to obtain by the public. So the dwelling, if approved, will be the second largest dwelling in the study area. However, there are 9 other dwellings. So again, 37.5% of the study area that are over 3,000 square feet. This is my second record, or my third record correction. Staff report on page 26 provides that 8 properties are over 3,000 square feet, or 33.3%. are over 3,000 square feet, when again, it should say 9 dwellings, 7 3,000 square feet and above, and 2 4,000 square feet and above. So the addition of the proposed 3,480 square foot dwelling, the average dwelling size for the analysis area will increase from 1,795 square feet to 1,862 square feet. So that's an addition of 67 square feet to the average of the 24 developed properties. Overall mass of the proposed development is minimized due to the single-story design proposals. Individually, the proposed structures will not be the largest structures in the study area. However, the combined mass of the proposed development, so the dwelling plus the accessory building, is larger than the combined mass of any other combined development within the study area. However, there is no explicit prohibition against proposing larger development, either individually or combined. The development just has to be compatible. And then finally, the proposal must be considered in its entirety against the general scale of the whole study area in its entirety as well. So based on the overall number of structures and wide miscellany of development sizes within the study area, it is reasonable to conclude that the proposed structures are capable of existing in harmony and are in fact compatible with the general scales, the height, dimensions, and mass of existing nearby development. And staff recommends the Wasco County Planning Commission dismiss this ground for appeal. Moving on to appeal ground number 5, which provides, quote, miscellaneous condition of approval number 2, violates NSA Ludo subsection 14100H by allowing existing Oregon white oak trees to be removed from the parcel, which is not necessary for site development. And I provided the applicable criteria in part. Essentially, it provides, except as is necessary for site development or fire safety purposes, the existing tree cover screening the development area on the subject parcel from key viewing areas and trees that provide a backdrop on the subject parcel, which help the development area achieve visual subordinates, shall be retained. And again, as stated earlier, no Oregon white oak trees are explicitly called to be removed in this request. Only one ponderosa pine is identified to be removed. And miscellaneous condition number 2, again, has no legal nexus, is not recommended. And that staff recommends the Wasco County Planning Commission dismiss this ground for appeal. Moving to appeal ground number 5. And again, I won't read this verbatim. I'll just read a pertinent part. Quote, the conditions of approval in the decision, including miscellaneous conditions number 1, number 6, and number 7 violate NSA Ludo subsection 14100H, end quote. I'll give you a second to read it. So this is the applicable criteria in its entirety. And again, pertaining to this specific appeal ground, I'll read the underlying part. Any of these trees or other trees required to be planted as a condition of approval that die for any reason shall be replaced by the current property owner or successors in interest no later than the next planting season, October to April, after their death, with trees of the same species or from the list in the landscape setting for the property. And then subsections 1 through 4 simply just provide requirements for care for the planting of and the maintenance of those trees. So in order to address this specific appeal ground issue, staff has recommended the following conditions of approval. A condition of approval, is recommended that all trees removed for development or fire safety purposes be replaced by the current property owner or successors in interest no later than the next planting season, October to April, with trees of the same species or from those trees approved in the landscape setting for the property. As well as this other or second condition, condition of approval is recommended requiring the proposed new trees and replacement trees shall meet the underlying requirements of subsections or of these specific elements 1 through 5, essentially. It's based on the recommended conditions of approval. Staff recommends the Wasco County Planning Commission dismiss this ground for appeal. Appeal grounds number 6, quote, the siting for the proposed septic drain field violates NSA Ludo subsection 14100H because it will result in the removal of existing white oak trees despite the availability of alternate sites for the septic drain field. Staff analysis, there is no indication in the plan, in the submitted plan, that Oregon white oak trees will be removed. Again, only one ponderosa pine tree is scheduled to be removed. Site plan exhibit B provides that the septic system is located in the oak stand. Quote, install septic drain field with least possible disturbance of existing oak stand, end quote. There is a condition of approval that's recommended that if additional trees must be removed for construction of the drain field or the structural developments, applicants shall demonstrate that the removal is necessary for site development or fire safety, and that no alternative development plan can be reasonably achieved without the removal of trees. And that if the removal of trees is found to be necessary for development, the applicant shall be bound by the condition of approval requirement requiring the replacement of the removed trees. If the removal of trees is found to be necessary for development or is not found to be necessary for development, the applicant must apply for modification under NSA Ludo Chapter 2, Section 2.220A or B. Staff recommendation based on the facts and recommended conditions of approval. Staff recommends the Wasco County Planning Commission dismiss this ground for appeal. Appeal ground number 7, quote, the decision violates NSA Ludo subsections 14.200A, B, C, H, K, and L because there is not substantial evidence that the proposed new development will be visually subordinate to the surrounding natural landscape when taking into consideration the proposed siting, size, design, shape, and landscaping for the new development, end quote. And so for clarification, staff has actually separated the analysis and recommendations for those grounds for appeal as 7A, B, C, H, K, and L in their individual sections. And this is how it was lined out in the staff report as well. So I won't read the pertinent criteria, section 14.200A, but it essentially requires that each development and land use shall be visually subordinate. It also requires that the decision have written findings addressing the number of key viewing areas, the distance from KVAs, linear distance along key viewing areas, distance and elevation, etc. Subsection A2 just provides that conditions, it allows conditions to be applied to the decision to help ensure that the proposal is visually subordinate from applicable KVAs. And these conditions can include the siting, design, and of course, new landscaping. Just wanted to hop back to the visual subordinate standard. It doesn't necessarily require the structure to be hidden, just that the structures must be not dominant in the overall area. As mentioned earlier, with the record correction, there are 5 key viewing areas identified instead of 3. Through detailed analysis of submitted application materials, site visits, and GIS analysis, staff determined that the subject parcel and development are not visible from SR 14, Highway 30, Interstate 84, and the Columbia River KVAs. And you can find explicit findings to that on pages 41 through 44 of the staff report. However, even though the Rowena section was found to not be visible from, or the subject parcel is not visible from the Rowena portion, it is visible from the Tom McCall portion of the KVA. This is a reference map that was developed by staff explicitly for this presentation. It's not within the staff report. It just kind of gives the commission a general example of what staff was able to acquire from site visits, GIS analysis, topographic maps with regards to the Rowena KVA. And visibility limits are caused by a combination of intervening vegetation from trees and elevation differences from where the KVA lies and where the subject parcel lies. So this picture was taken by staff from the Rowena KVA trailhead, looking in a southwesterly direction towards the subject parcel's location. As identified in the photo, the general location of the subject parcel is obscured by vegetation and kind of a elevation difference. This is a reference map, again, created explicitly for this presentation. It's not within the staff report from memory. Or perhaps it is within the staff report. Either way, it illustrates just the general visibility of the subject parcel from Tom McCall, KVA. This photograph was taken by staff, and it essentially provides kind of a view of the oak stands from the corner of the subject parcel. Sorry, I just lost my, give me 1 second. So this was I've added a little bit of color just to kind of demonstrate some of the mitigation techniques of the actual proposal. You have the 30 to 50 foot high oak forest backdrop in the northwest corner of the parcel, combined with matte dark earth tone colors of the single story proposed structures. And then, of course, the proposed vegetative screening. This is essentially, in a nutshell, the overall proposal. Now, of course, the building materials are non-reflective, and I believe, yeah, that pretty much ends that. So, considering distance from KVA's, intervening topography, the subject parcel's existing vegetative backdrop, proposed vegetative screening, and the proposed colors and construction materials, staff finds the proposed development can achieve visual subordinates and recommends the Wasco County Planning Commission dismiss this ground for appeal. All right. Give me 1 second. I think my slideshow might have gotten out of whack. Okay, so this is Appeal Grounds 7B. Provides that new development shall be cited to achieve visual subordinates. Essentially requires development to be cited to achieve visual subordinates from KVAs unless the best location is also within an area identified as a sensitive area. So a sensitive wetland, a riparian corridor, an area that has sensitive wildlife sites. Staff analysis provides that there's no state or federal delineated wetlands or riparian corridors on the subject property. The parcel is not within a U.S. Forest Service identified Oregon white oak habitats. The parcel is not within the CRGC Wildlife Habitat Plan, Columbia River Gorge Commission. that sensitive plants are not identified on the subject parcel. No comments were received from CRGC or US Forest Service. And then, of course, we have to consider findings of 14200A as well, where 14200A found that the overall placements of the structures in their location would achieve visual subordinates from the Tom McCall KVA. So development will be constructed with 100 to 200 feet southeast of the forest in order to best utilize the forest backdrop to achieve visual subordinates. Considering previous findings for section 14200A, staff recommends that the proposed development can achieve visual subordinates and recommends that the Wasco County Planning Commission dismiss this ground for appeal. So these two or grounds for appeal tend to converge. So I've added them both on this slide and addressed them accordingly. Appeal ground number 7C is similar to appeal ground number 8C. And appeal ground number 8C provides a quote, because the proposed new development is not cited to achieve visual subordinates, utilizing existing vegetation, and because the decision relies on new landscaping rather than existing landscaping, it fails to adequately consider alternate siting and fails to require any alternate site that would avoid the need for new landscaping whenever possible. The decision violates NSA LUDO subsections 14200C and K1. And so I've provided the applicable criteria 14200 or 14200C. Staff analysis provides that we have a relatively flat slope on the property, so 6 to 8% slope. Approximately 7+ acres of the property does not contain tree vegetation, so it's essentially open grass. The location of development takes advantage of the 30-foot to 50-foot high oak forest. And again, the location of the proposed development is 100 to 200 feet southeast of the oak forest. The development, at least within the application materials, was cited in such a way to not encroach upon the oak forest. No Oregon white oak is proposed to be removed, and we have to go back to consider the findings for sections 14200A and B. And staff notes that the appellants provided commentary with an attached visual analysis report issued by Quatrefoil Inc. in 2002 for the Friends of the Columbia Gorge. The report provided site plan and visual analysis for an earlier development request made by the current applicants. The report is titled Curry Cabin Visual Analysis Report and provided 5 alternative locations for the proposed development. Staff addressed each of the 4 proposed locations as well as the 5th location, which was submitted by the applicants. So in short, the Curry Cabin Visual Analysis Report's findings were not pertinent to this request. However, the staff report does provide some examination of the Curry Cabin Visual Analysis Report, and you can find that on pages 45 through 53 of the staff report. So considering the vegetation and slope of the subject parcel on previous findings for section 14200A and B, staff finds that the proposed development utilizes existing topography and or existing vegetation in order to achieve visual subordinates and recommends the Wasco County Planning Commission dismiss these grounds for appeal. Appeal grounds number 7H, quote, the decision violates NSA LUDO subsections 14200A, B, C, and H. I won't read the rest, end quote. I've provided the applicable criteria that requires that new buildings shall not be permitted on lands visible from key viewing areas with slopes in excess of 30%. Staff analysis and recommendation, slopes in the development area range from 6 to 8%. Staff finds that the request complies with section 14200H and recommends the Wasco County Planning Commission dismiss this ground for appeal. So provided are 3 grounds for appeal that concern section 14200K. They're numbered in the staff reports as appeal grounds number 7K, 8K1, and 10K3. So I previously read, I believe, into the record grounds, appeal grounds number 7K and number 8K1. But appeal number 10K, I'll go ahead and read that. Quote, because the decision allows the applicants to defer installing any new landscaping for up to 1 year rather than as soon as practicable and prior to the project completion, the decision violates NSA Ludo subsection 14200K3. And I've provided 14200K for your review. Subsection 1 requires that new landscaping shall be required only when application of all other available guidelines in this chapter is not sufficient to make the development visually subordinate in the GMA and meet the required scenic standard of visually subordinate. Subsection 2 provides that any vegetation planted pursuant to this criterion shall be sized to provide sufficient screening to make the development visually subordinate within 5 years or less from the commencement of construction. And then sub 3 just requires that landscaping shall be installed as soon as practical and prior to project completion. So staff analysis included why the landscaping is necessary. It's just relatively flat slope on the property at 6 to 8%. And then you've got 7+ acres of the property that contains no tree vegetation whatsoever. Furthermore, the location of the development 100 to 200 feet southeast of the forest is designed to utilize that forest backdrop. The oak forest is the primary vegetation used to mitigate visibility from the Tomahawk KVA. And of course, no oak trees are planned to be removed because of this design or this design placement. The request will incorporate 17 planted trees that will be planted to the southeast of the structures. We have to also incorporate the findings for section 14200A, B, and C. Furthermore, conditions of approval are recommended, requiring the planting of the 17 native trees on the south and southeast side of the proposed development in accordance with the proposed site plan or site plan exhibit D to be planted as soon as practical and prior to project completion. And that is a record correction. That's going to update the condition that's within the staff report currently. That's on page 61. A second condition of approval is recommended, requiring vegetation planted to be sized to provide sufficient screening to make the development visually subordinate within 5 years or less from the commencement of the construction. And that is another record correction for page 61 of the staff report. In discussing vegetation and whether it is required, it should be mentioned that in the 2002 Curry-Kaplan Visual Analysis Report, that of the 4 proposed development locations, alternative locations 3 and 4, where had the structures located to the far south edge of that oak forest, right outside of the oak forest. Both of those alternatives required vegetative screening. Alternative 2 placed the structure on the kind of the within the oak forest and advised that the vegetative screening might be required, depending on the numbers and locations of existing trees that would have to be removed. And then only alternative 1 didn't necessarily require new trees because it had the proposed structure located within the actual forest. And it made no mention of tree removal, however. So considering the vegetation and slope of the subject parcel, proposed vegetative screening, recommended conditions of approval, the previous findings made for section 14200A, B, and C, staff finds that the proposed development achieves the requirements of subsection 1400 or 14200K, and recommends the Wasco County Planning Commission dismiss these grounds for appeal. All right. Appeal grounds 7L and appeal ground number 9 cover the same criterion, 1402L. And we'll go ahead and read appeal ground number 9 into the record. Quote, the decision violates NSA Ludo's subsection 14200L because there is not substantial evidence that the proposed new development, when considered in conjunction with existing and reasonably foreseeable future development in the surrounding landscape, will meet the scenic resource protection standards and achieve visual subordinates on a landscape level, and will not result in adverse effects to scenic resources, including cumulative adverse effects. So the criteria is fairly straightforward. 14200L is a determination of potential visual effects and compliance with visual subordinates policies shall include consideration of the cumulative effects of proposed developments. Again, I put cumulative effects and adversely affect on the screen to simply just kind of remind us what it means. Cumulative effects are the combined effects of 2 or more activities. And in short or in part, adverse effect is a reasonable likelihood of more than moderate adverse consequence for a scenic, cultural, recreation, or natural resources of the scenic area. So in looking at and analyzing 14100C, we take into consider, staff took into consideration findings for 14200A, B, and C. Or I apologize. In looking at 1400 or 14200L, I believe, staff took into consideration previous findings for section 14100C, as well as findings provided for within sections 14200 A, B, and C. So just to kind of explain some of the additional analysis that was done for this specific appeal ground, the 35 units of land within the 1,500-foot study area equaled roughly 664 acres. That was approximately 440.8 acres that was undeveloped. The United States owns 3 parcels at 366.37 acres. Friends of the Columbia Gorge Land Trust owns 33.6 acres. So between the US owned and Friends owned land, you've got about calculated approximately 83.2% of the undeveloped land. So they own quite a bit of that land that's undeveloped. And so if staff assumes that the land owned by the US government, Friends of the Columbia Gorge Land Trust, is held solely for recreational or resource use, So that means no residential, commercial, or industrial uses. And staff might logically assume that the remaining undeveloped land that's owned by Tom Rye, Walter Curry, and Elizabeth Dexter, the applicants, Wasco County, Robert Niehaus, and an LLC, a recorded LLC, that roughly 40.11 acres of the 664 acre study area may actually be developed in the future for residential, commercial, or agricultural use. And I also need to include a record correction on page 63. Page 63 should provide that 40.11 acres is 6% of the 664 acre study area. And that it may be structurally developed for residential or agricultural use per the applicable zones. So minus areas such as yards, private driveways, patios, decks, the approximated physical development for the 664 acre study area equals roughly 61,224 square feet. So that's 1.4 acres or 0.21% of the overall study area. And again, I have another record correction on page 63 of the staff report. It should read that adding the total 4,980 square feet of the proposed structural development will increase the overall developed portion of the study area to approximately 66,204 square feet, or 1.5 acres, or 0.22% of the overall study area that is structurally developed. So adding the 4,980 square feet to this is not going to increase the overall percentage of the developed area that much, actually. So 0.1 acres, actually. So considering the findings for section 14-100C, as well as sections 14-200 A, B, and C, and findings that the proposed development will not result in adverse effects to scenic resources, including cumulative effects or adverse effects, staff recommends the Wasco County Planning Commission dismiss these grounds for appeal. Our overall staff recommendation is to approve the request with amended conditions and findings as described in attachment A of the Planning Commission packet, and those amended findings and conditions that were provided during this hearing. And then I open it for questions.
Thank you. Thank you, Daniel. I appreciate the presentation. And at this point, following the presentation, I'd like to ask the commissioners if they have any questions for staff, particularly for Daniel.
Yeah, I had a question for Daniel.
Please.
Daniel, I didn't understand the legal access issue. The property is on Dell Road, right?
Yes, Commissioner.
What was the, maybe I misheard. I thought you said there was a legal issue raised around access.
That is incorrect, Commissioner.
Oh, okay, all right. Thanks.
Thank you, Commissioner Hargrave. I'm opening it up for commissioners if they have any other questions for staff. Okay, hearing none. Does the appellant, which is the Friends of the Columbia Gorge, and or his representatives or the Friends of the Columbia River Gorge wish to present anything? And if so, please state your name for the record.
Yes, I don't know if you can hear me. This is Jeff Kleinman. I am attorney for Friends of the Columbia Gorge.
Yes, Jeff, thank you. Please, you have the floor.
Thank you. I'd like to activate the video and not sure how to do that. Daniel?
Staff, can you help with activating the video? I'm not quite sure.
Yes.
Yeah,
If you look down at the bottom of the screen, there's
There
a
it
button.
is. There it
yeah.
is. Yeah, that was not visible before.
And Chair, this is Director. We actually need the addresses as well as names for the record. Thank you.
Oh,
Sure.
Thank
We'll
you
do
very
that.
much.
Okay. Thank you. This is Jeff Kleinman, Kleinman. My address is 1207 Southwest 6th Avenue, Portland, 97204. Telephone 503-248-0808. I am the outside counsel for the appellant in this case. Want to thank Daniel for getting this set up on pretty short notice. To have me appear on YouTube, that was, excuse me, on Zoom. That was really not my preference, but I have a conflicting matter tonight, so couldn't make the drive out to the Dell. So again, thanks to Daniel. I am going to make brief introductory comments, and then we have a couple of folks in attendance. So let me give you the order of our testimony. Again, I'll go first quite briefly, and then we have Brian Bainson, who is a landscape architect with considerable experience working in the Gorge Scenic area, including working on several applications on behalf of applicants or proponents. After Brian speaks, then I will make some additional comments, not too lengthy. And then finally, Steve McCoy, who is a staff attorney for Friends of the Columbia Gorge and is present with you, will testify this afternoon. And of course, after that, we'll be open to any questions that you may have. In a nutshell, Friends of the Columbia Gorge requests that the appeal be allowed and the application either be denied outright, which we think is appropriate, or modified to comply with the criteria that apply to this application. And modifications would have to be quite substantial in this instance. Per Chair Willis's instructions at the beginning of the hearing, to the extent necessary, I'd like to request standing be recognized for myself and for Friends of the Columbia Gorge. I would also like to request that the evidentiary record be held open for at least 7 days for additional submittals by the parties. What we're looking at here is a basically trophy project, a house and an accessory building, which together are just shy of 5,000 square feet, all on one level, which helps somewhat with the visual impact, but really creates quite a sprawling compound and an extraordinarily bad precedent for any future applications that are within the scenic area and subject to the same criteria. The other witnesses are going to discuss those issues in more detail, but that's the bottom line. And what's happened here is that the applicant, instead of seeking first to meet its burden of proof and show compliance with the county's criteria, instead has chosen to maximize its view of Mount Adams, pushed this large structure or pair of structures forward into an open field in order to maximize that view, rather than taking advantage of the screening of the existing grove of Oregon white oaks, Quercus garryana, and then attempted to work backward to justify how this application complies with the criteria, which for all the reasons that have been outlined by my client, it simply does not. And I would reiterate, the burden at all times is on the applicant and not on opponents, and frankly, not on staff either, to try to find a way to justify an application which the applicant has failed to justify. What we have here is a compound of structures that is not at all visually subordinate as required. So again, approval of the application, denial of the appeal would set a really poor precedent in Wasco County going forward. And with that, I'd like to introduce Brian Bainson, who will present on the landscape-related issues.
So Brian Bainson, last name Bainson. I am a landscape architect with Quatrefoil Incorporated in Portland, Oregon. Address is 415 Northeast 65th Avenue, 97213. First, I'll start out just a little bit of my background. As Jeff mentioned, I've been working on projects out in the scenic area for the last 30 plus years. I've worked on both sides, representing both applicants and looking at scenic area issues from county perspectives in various permitting issues. One of the first projects I worked on many years ago was working for Skamania County, representing them, looking at a visual analysis of the bee house, which I was part of helping resolve that issue many, many years ago. I've also done extensive work with both U.S. Fish and Wildlife Service at their various properties in the gorge, some of those in the scenic area where we've actually, as an applicant, proposed various projects on those fish hatcheries that have been approved through the scenic area and built. We've also worked with Federal Highways, ODOT, Oregon State Parks, and other City of Mosier and other municipalities on various projects within the scenic area. So fairly knowledgeable about what goes on within the scenic area and what it takes to really meet the conditions of approval for various projects. In addition to that, from a training perspective, one, as a licensed landscape architect, I've been licensed in the state of Oregon since 1993. Early in my career, when I was involved in my first project in the gorge, which was helping with the master planning for the Crates Point Interpretive Site here in the Dalles, went through a series of trainings with Jürgen Hess, who at the time was with the Forest Service, who was instrumental in helping to craft the whole visual subordinates issue, and went through a series of trainings with him 30 years ago onto what it actually meant to be visually subordinate. So again, we got a little bit of an education on that from the planner. So what I'm going to do next is just go through some of the concerns and issues that I looked at. And again, I was first involved in this project back in 2002 when the applicant first proposed building on this site. And at that time in 2002, we were looking at a very different project, a much smaller home to be located on the site. And many things have changed since then. But again, back in 2002, we did help craft a plan that was approved and permitted, just never acted on and constructed by the applicant. In the intervening years, the concerns about the oak habitat and the oak trees is a much greater and important issue. We know a lot more about the importance of oak habitat in the Columbia River Gorge. Back in 2002, it was less of a concern. It still was a concern to preserve and protect those trees. But again, we took a little bit more of a free hand in looking at how to site the house within the oak. So what we're looking at today, 20 years later, is obviously a much larger building and development site. We have the issues of concern related to the oak trees, which we agree with, that they're of primary one of the primary concerns, along with this visual subordinates and the scenic issues. But what we're looking at here is a project where the current proposal of siting of the home, accessory structure, the drive and approach to the development is sited within a large open field on the site. Right now, that open field runs pretty much continuously across the site from north to south, with the existing oak grove to the west of the site, and then some existing development that's also west of the site. So what we looked at in doing our analysis was what that proposed development would look like setting out in that field in front of the oak grove from the primary KVA we're concerned, which is Tom McCall. And by siting that structure over 200 feet out into the existing field within 150 feet of the adjoining property, it really extends that visual impact of the development out into this pastoral landscape, which is one of the things that we're trying to protect within the scenic area. So again, there was nothing in the application in the decision that we could find that said that the applicant or the county looked at alternatives. So again, we didn't have access to the site today as we did in 2002 and 2002. We were able to get on the site, and I did have all of my photographs from 2002, and really very little has changed in the 20 years on the site itself as far as the condition of the oaks and the other plants that exist on site. So again, I felt pretty confident that I had a fairly good understanding of the site. So we looked at how could you site a development such as what's being proposed on the site to better be visually subordinate from the KVA. And it's clear that the existing trees, which the planner rightfully so brings up the point that they are an important part of achieving visual subordinates by the proposal becoming part of the mass of those existing trees, would be far better served if by shifting the development further to the west on the property to preserve the open pasture, open field, putting the house and accessory structures and driveway within the visual plane of the existing oak grove and the development to the west. So we actually provided just a quick sketch of that, which I believe Steve included in the package that he was handed today. And again, this is just one potential alternative that we feel strongly would achieve visual subordinates quicker and more fit, and working with the property in the way that it's supposed to be, where you're utilizing existing vegetation and existing topography as the primary means to achieve visual subordinates. I think it was interesting during the planner's testimony that he kind of dismissed the proposed trees that are being proposed as part of the visual subordinates and putting it all solely on the oak grove as the primary means to achieve it, when you're taking a very geometric mass of buildings and roads, and I think it was stated that amount to over 5,000 square feet of development, and putting that geometric mass out into a pristine field against the very organic trees that with no matter, and then you're relying solely on building materials, colors, and the oaks to achieve visual subordinates. I don't believe that actually would. And that the proposed trees, there's no evidence showing that within a 5-year period of time, the proposed vegetation that is being proposed would actually achieve visual subordinates in a 5-year time period. There's no plan to, how those trees would grow and what their size would be. And it's known that in this part of the county, plants, particularly native plants, oaks, ponderosa pines, and other natives grow very, very slowly. So plants planted today aren't going to look a whole lot different than they will in 5 years. And there are a series of ponderosa pines on the site that were there in 2002, still there today and 20 years later. And one can compare photographs from then to today and realize that those trees really have not grown very much. I mean, they've grown their normal 3 to 6 inches a year, but they're still relatively small trees in a 20-year period of time. So again, vegetation grows very slowly. So is there a way to site the development so you're not relying so much on that vegetation? The primary use for the mitigation vegetation is to break up the lines of the home, the proposed home, which the one good thing about the proposal, that is a 1-story development, 15 feet general height, with a fairly simple line, shed roofs. Those are all good things from an architectural standpoint that really will help the home achieve visual subordinates. And I think what I'm saying is that the existing home and garage, and I'm not getting into the size of the structures now, I'll leave that to a little bit later to talk about size, could work on this site with better siting. The other thing that was brought up, which is of a primary concern now, is the septic system. Again, in the proposal, the septic system is shown to be located within the existing oak grove. Again, there's no existing information about location of existing trees, no information about the design of the septic system, the lengths of the drain field, the amount of room necessary for construction. So to review and analyze the impacts to the oak trees, whether they would need to have any removed during construction, or whether the impacts from construction and from the change in the environment to those trees by introducing all of the septic water to trees that have been growing for, I think what was stated by the planner, 300 to 400 years with natural rainfall, what those impacts would be to that oak grove over time. So, and again, what we found in the application is that there was no mention or talk of were there alternative locations for the septic field that were looked at? Was this determined to be the best site? And again, I am not a septic designer, so I would leave that to a septic designer, but it seems to me that the burden of proof should be that to prove that this is the only location the septic system can be placed. And then if that is the case, that adequate information about the design of the system and the existing trees is provided, so when the county makes its decision on this proposal, they know what the impacts to that oak grove will be during construction, after construction, and again, you're looking at a tree that does live for hundreds of years, what it will be down through the decades. And I don't believe any of that work was done. And so that is of primary concern. And I don't believe, as the planner has stated, it should just be dismissed as or denied as a legitimate grounds for appeal. The other thing I'll get back to about the building and the placement of the building is another LUDO requirement that talks about accessory structures, outbuildings shall be clustered together as much as possible, particularly located at the edges of meadows and pastures and farm fields to basically preserve that overall character of the landscape, which is very much part of what visual subordinance is about. But what we're seeing here is a proposal that has taken the development, the two structures, and I think importantly also, which we kind of gloss over, is the driveway, the turnaround for the house, and divides that field into two sections. And again, the proposed location of the dwellings, we feel is going to require mitigation vegetation to make it visually subordinate. And again, we have concerns that there was really not enough adequate information provided for what that vegetation is and how it will perform over the next 5 years to achieve that visual subordinates. I think on the issue of the size of the structures and the compatibility with the neighborhoods, I'll leave that to Stephen's testimony. But I will say that, when you look at the KVA and the views from the KVA and look at the development that is visible and realizing that the sizes of what is visible and the size of those structures, and that this development is so much larger than most of those other existing development within that KVA, there is a cause of concern about the size of the structures. But again, I think with more information about the mitigation and a potential reciting of it, I think the applicant could potentially come back with a plan that would mitigate and be visually subordinate without dramatic changes to the size. But again, I'll leave the argument about the appropriateness of almost the 5,000 square foot of one-story building as to the compatibility of the neighbors to others to talk further about. With that, I'll return to Jeff, just to ask Jeff if he had any other questions that I didn't cover that he'd like me to step back and provide additional discussion on.
Okay, thank you, Brian. I think Brian has covered the issues pretty well. They're all directly related to the code criteria, which the applicant has failed to make a showing of compliance with. There is one thing that, as a lawyer, I want to make clear. Brian, in several instances, referred to, quote, concerns that Friends of the Columbia Gorge has with the application. And I would ask you to please substitute for the words concerns, failures to meet the burden of proof and to demonstrate compliance with the county's approval standards for this development. These are not merely matters of concern, which is a very polite way of putting it, but they go to the heart of what was required here and has not been done. In my introductory comments, I said I would have a little more to say, but I would be brief, and I think I can adhere to that, even though I'm a lawyer, and usually when we say stuff like that, it never happens. So just taking a couple of minutes. What we have here is really a failure to meet the baseline for the application, or failure to meet the burden of proof. So for example, if you look at the application, it really fails to set out in any detail the characteristics of the site, which the applicant is required to set out. So frankly, the application should not have been deemed complete in the first place. It was not complete. There was not an adequate showing of the vegetation or of the topography. There was not a full topo provided, which is incredibly important in terms of proving what you need to prove here in terms of compatibility. There has been clearly a failure to take advantage of both the available topography and the available vegetation to minimize the impacts of this quite large complex or compound. Brian touched upon the effects of the septic system, which have not been analyzed, but it appears to us that the septic system, which is to be placed under or within the key grove of Oregon white oaks, is going to necessitate the removal of oaks. It was incumbent upon the applicant to demonstrate that the septic field or drain field can be sited in a way that's not going to cause the removal of oaks. And if it becomes necessary to remove such trees, as Brian pointed out, you're not going to see mitigation for probably decades, given the rate of growth. This whole notion that, well, we can look at trees that have to come down later and then plant new trees, that's a big leap. And it gains nothing in terms of substituting screening within the 5-year period required. Basically, the staff decision as currently crafted provides carte blanche or a license to the applicant to remove white oaks or ponderosa pines later after the application is approved without further scrutiny from the public or experts. Just go ahead and tell us you need to remove something, and then we'll tell you what kind of minimal scrub you need to plant somewhere to substitute for it. And the fact of the matter is that because the vegetative screening, the protection of the white oaks, the existence of the white oaks is core and essential to the success of this application, it is a violation to allow the applicant to go forward later and say, oh, you know, we need to remove these oaks or we need to remove these pines. We didn't realize that, for example, the septic field is going to compel the removal of these trees, or we've learned that placing the septic field here is going to kill these trees. So please modify our approval and allow these things to take place. When it comes to the key approval standards, that is an unlawful order approving the application, unless each such removal any significant modification in what the Planning Commission approves in this case is subject to further review in a public process in which the public can participate. And that's Oregon land use law. You can't have that sort of modification or change which it directly impacts the approval standards under which this would be allowed now, unless you provide a public process. It cannot be left to staff. But that's the way this proposed order is structured now. There are multiple reasons to deny this application, any one of which is sufficient to defeat it. In other words, for all the grounds that are set out by Friends of the Columbia Gorge, they need not prove every one of them or prove that the applicant has failed to meet its burden as to every one of them, or a majority of them, or even two of them. But these are all elements of the applicant's burden, and if they have failed in any respect, then the application must be denied and the appeal must be sustained. I would just add that with respect to the photographs which were provided by staff as part of staff's presentation, to supplement the applicant's work, because the applicant didn't provide those graphics. It's unclear what the focal length was on the lens and whether those photographs are sufficient to demonstrate what they're intended to demonstrate. And for that reason, those photos should be disregarded and not be deemed to be part of the applicant's burden of proof. So again, unless there are any questions of me, I appreciate your time and your attention to this appeal. And I'll turn things over to Steve McCoy.
Can I just say one thing before you start?
Yeah, sure. Actually, Brian Bainson wants to jump in and mention something.
Yeah, just this is the point you made, Jeff. I just wanted to kind of reiterate, particularly on Exhibit K, view from Tom McCall Point. I believe that I believe this was used to represent visual subordinates for the application. There's a small rectangle drawn in front of the existing oak forest. It truly does not represent the accurate scale of the home. I think that there's if you look at the site plan, which shows the distance from the proposal to the property line, the location of it in relationship to the road, it does not appear to be an accurate representation of the proposed development. It also doesn't represent the drive and the turnaround or the accessory structure on that drawing. So I think that exhibit is flawed. And again, it was one of the main proofs of visual subordinates that was in the decision.
Jeff Kleinman again, let me add one point. I just want to be really clear that Friends of the Columbia Gorge is not opposed to a residential development on this site. That's not what this is about. They worked to assist this applicant in getting an approval in 2002. And we're not even saying that that much smaller home is what the applicant should be confined to here. A larger home should work. But the applicant has not met its burden as to the siting and compliance with the various criteria. And if the applicant wants to, again, work with Friends to come up with something that would be supportable and cause Friends to withdraw its objections, that would be fine. So, we're not being sticks in the mud. A home can be sited here, an accessory structure can be sited here, but you've got to go through the hoops and make the required proof. So again, with that, I'll turn things over to Steve.
Thank you, Jeff. One thing I wanted to follow up on that Mr. Kleinman just mentioned was deferring the removal of the trees to a staff decision at a later point. He said that was against Oregon's land use law, which it is. But in addition, there are two decisions out of the Gorge Commission. One is called the Bacchus decision. It's spelled BACUS. And the other one is called the Eagle Ridge decision. And both of them denied applications, overturned approvals due to a lack of information. That the conditions of approval pushed things off into the future, which is exactly what's going on here. And moving on to compatibility, perhaps the most important aspect to the neighborhood, as evidenced by letters from the neighbors, is that the decision violates NSA Ludo 14100.c because it does not ensure that the proposed new buildings will be compatible in size and overall mass with the existing nearby buildings. This is a really important aspect of scenic resource protection standards. It ensures that buildings will not be more noticeable because they are out of scale, and it prevents the size of buildings from creeping up over time such that the cumulative adverse effects, which are prohibited, would be incurred. To put this compatibility requirement into effect, the Gorge Commission developed standards to guide county compatibility analysis. I will direct you to page 7 of the exhibits that we passed out. At the top, it says methodology for determining compatibility of new development. And this is the guidance given by the Columbia River Gorge Commission on how counties are supposed to do this analysis. The first step is that the decision maker should look at the design guidelines in the landscape setting for the proposed development site. Landscape settings were developed to ensure that development is harmonious with its surroundings. Here, the landscape setting is rural, residential, and pastoral, which means that both the rural, residential, and pastoral landscape settings need to be complied with. For the pastoral landscape setting, NSA Ludo section 14400.a.1 requires accessory structures, outbuildings, and access ways to be clustered together as much as possible, particularly towards the edges of existing meadows, pastures, and farm fields. However, the proposal has the dwelling, the accessory structure, and the access way, the driveway, out in the middle of the field, virtually splitting the field into two pieces. Citing the proposed buildings in the southwest corner of the parcel, but cluster them and the driveway together at the edge of the field as required by the county ordinance. Also, NSA Ludo section 14400.a.2.a requires that vegetative landscaping shall, where feasible, retain the open character of existing pastures and fields. The proposed location of the dwelling requires vegetative screening away from the other vegetation on the parcel, virtually in the middle of the field. Citing the proposed buildings in the southwest corner of the parcel would allow any necessary vegetative screening to blend in more with the oak woodland and retain the open character of the field, which would meet this requirement of the ordinance. Next, the county is supposed to define a study area by determining the boundaries for nearby development. According to the Gorge Commission's guidance, typically a radius of 1/4 mile from the proposed development is chosen as a study area. If there are not at least 10 existing buildings of that similar use within the 1/4 mile study area, the county should expand the area to gather a sample of at least 10 similar type buildings. Instead, the decision went out to 1,500 feet, even though there were 20 dwellings within the 1/4 mile. In fact, there were over 10 within 750 feet. That was the initial, which is what the Gorge Commission is looking for, is at least 10 dwellings. The lone property with a larger dwelling is not within a 1/4 mile. And as I'll get to in a minute, it should be discarded as an outlier nevertheless, because that is part of the Gorge Commission's guidance on this as well. The proposed dwelling would be the largest one within a 1/4 mile. Next, the county should evaluate each building separately, not the cumulative size of all existing buildings on a parcel. That was what was done here, at least in the narrative that Mr. Doherty gave. They aggregated all the development on each parcel rather than simply talking about the dwelling and the accessory structure on their own. The next step is to calculate the size of each building's visible mass by using information from the county assessor's office. This was done by the county. Next, evaluate the height of proposed and existing buildings based on the number of stories listed in the assessor's records. This was done as well by the county. So next, determine if there are any outlier buildings and remove them from the study sample. If there are buildings in the vicinity that are significantly larger in size than the rest of the buildings in the study area and do not present an accurate depiction of the average size of the buildings in the area, these should be removed from the compatibility study. The county did make spreadsheets for 750 and 1,500 feet from the parcel. Part of the exhibits that you should have now in an email from Mr. Doherty, shows charts of the dwellings within 750 feet, a quarter mile, and 1,500 feet of the parcel. The first one on page 9 of Friends Exhibits shows that there is one dwelling, number 2 on there, that is almost 3,000 feet, 3,000 square feet, keeping in mind that this proposal is for 3,480 square feet. Clearly 2 is an outlier. It's much larger than any of the others, almost by 1,000 square feet, and it should be discarded. So for that, it looks like more like 2,000 is what would be compatible, or even a little less. Whenever you look at the quarter mile one on page 11 of the exhibits, again, what we're going for here is 3,480 square feet. So essentially the 3,500 square foot line there. Again, 2 is an outlier and must be discarded under the Gorge Commission's guidance. And then finally, on the very last page, the square footage of buildings within 1,500 feet. Clearly, 2, 19, and 20 are outliers here that should be discarded. And again, it doesn't get you close to the 3,500 square foot line. Finally, per the Gorge Commission's guidance, the county should evaluate the consistency of the proposed building with the general scale of existing development in the study area. No matter which of the distances are chosen, once the outliers are discarded per Gorge Commission policy, the proposed 3,480 square foot dwelling is not compatible with nearby development, which maxes out in the largest and the 1,500 square foot once outliers are discarded is 2,352 square feet. Thus, the application should be denied and the compatibility procedures laid out by the Gorge Commission should be followed. One thing that I wanted to mention is that this is a de novo hearing. A de novo hearing means that the applicant is responsible for proving that, given the applicable law as a matter of first impression and using the evidence in the record and presented at this hearing, that the development is lawful. This isn't about assignments of error or certain points that we raised before. This is all about, this is a de novo hearing, which means that everything needs to be proven from scratch. For the reasons we have discussed, the application should be denied. Jeff, anything else?
I think that completely covers it. Each of us would be happy to answer any questions that the commissioners have. Other than that, we thank you for your time and for your attention this afternoon.
Thank you very much for the outline of everything that you've presented. I would like to now turn it to the Planning Commission and ask if any of the commissioners have any questions from what they've heard. Commissioners, I am asking for any comments on what you've just heard. And Director, I would like to know if I as chair can comment.
Yes, Chair, you can.
Okay. And commissioners, I do urge you to chime in here if you're hearing anything that I've heard. What really struck me about the testimony that was given by Friends of the Columbia Gorge is the idea of the burden of proof and the fact that this is a de novo hearing. And if there are certain standards that need to be met, and on hearing this testimony, I do have concerns about many of the factors that have been stated
Sorry, Chair. Sorry,
yes.
Chair. For the record, this is Director Housing Limber. We still have additional people who are registered to testify.
Yes.
Deliberation. So usually this portion of is reserved for questions of the appellant.
Thank you. I will move on. This is for, what I have is that the Planning Commission had any questions about it. If not, then we can move on to the next piece.
So the next piece would be to call those in favor of the appeal. And it looks like
The next piece that I have is whether the applicant or their representative wishes to rebut.
okay.
So I am now asking, does the applicant or the representative wish to rebut?
Sure.
And if so, please state your name and address for the record. And the scope and extent of the rebuttal shall be limited to the issues raised during testimony and shall not be used to introduce new evidence.
My name is Scott Curry. I'm the applicant. My address is 4408 South Corbett Avenue, Portland, 97239. My phone number, 503-407-6695. So my head is spinning a little bit. I guess I will respond to some of the things that I heard here. The first phrase, trophy project, is an insult. This is a family home that we have designed and sited. There is no wine cellar. There's no lap pool. There's no panic room. There's no spa. There's no wine bar. This is a family home that we designed. We have a large family. There's been a lot of talk here about the size of the structure. Liz and I, my wife, who's the architect, we bought this parcel 20 years ago. We have 5 children, now ranging in age from 25 to 31. We started bringing them to the parcel at age 5 at the youngest. They're attached to this parcel. The reason we want to build here and develop here is because it is a touchstone for the family. So we need space to host them. Of this 3,480 square feet, which seems to be causing inordinate concern, I would mention, first of all, that a portion of that, 840 square feet, is to house our children and their spouses when they visit, or our aging parents. We've got 4 senior parents right now, age 88, 88, 80, and 80. One of them may live with us someday. This is our final home. This is a 20-year house for us. I'm age 65. We want a place where we can host our children or host our parents if we need to. So the notion that we are creating a trophy is embarrassing, frankly, for Jeff to mention. So how did we come up with the house? We first sat down and decided who was going to be there. Liz is an architect. We know that we have to live with it because we've been through this before 20 years ago with Los Amigos. What we've tried to do here is to create an efficient place, keep the roof low. The slope is 1 to 12. We've tried to provide a living space for our family while still complying with the provisions of the National Scenic Act. We have, in terms of how we started this, is we started looking at some of the other applications, some of the other approved site plans in the area, one of which is directly across the street. Rob and Karen Wardwell. Their structure is 99 feet long. We put ours at 99 feet. We put the Z on it so that we could get the additional square footage we thought we needed to host our family. We put the accessory structure, which has a little art studio in it. It's nothing extravagant. There's nothing going on in there. It's not there seems to be concern about Airbnb or renting these places out. This is a single family home that we have worked to design here. The home itself, in order to comply with the National Scenic Act provisions, it's got 42-inch overhangs on both the north and the south side. It's got 30-inch overhangs on the ends. The glazing on the east end is 8.4% of the total. We don't have floor to ceiling windows. It faces to the north, away from Tom McCall Point. The glazing on the north end, which is the most extreme, is about 18% of the vertical footage. Tom McCall Point, I can't believe is actually being brought up, right? It's 6,600 feet away. If you stand up there and if you look 180 degrees, and if you hold out a pencil, you look at that eraser, that's our house. So Brian, I'm sorry, this notion that the photograph is misrepresented is baloney, actually. You stand up there, you can barely see the place. And I would also add that Tom McCall, the trail, of course, is open 6 months out of the year. So half of the year, nobody's out there looking at this house. So not only have we taken the design and done everything that we know how to do to make it visually subordinate, the whole place, I mean, the viewpoint is 6,000, it's 1.25 miles away. And if you go up there, and I have gone up there, you can barely see it. It looks like our house is gonna look like a little dot on the horizon, the backdrop of the trees. So the siding of the house. Here's the way we did it. We walked the parcel. These folks have always wanted us down in the trees. So the way our 10 acres, 9.53 acres works, the reason the trees are in this northwest corner is because that's where the water goes. Okay, it's the bottom of the funnel. Yet these characters would put us down there. That's where they tried to put us 20 years ago. And we unfortunately agreed to it. And then when we stepped away, we realized what a mistake we made. So 20 years ago, we agreed to something. We felt a little coerced and intimidated. We were a lot younger. I was 45 years old. We had a lot younger family. And so we agreed to it, and that was a grievous error. The reason we're here today is because we did not route this application through them this time, and they are ticked. That's why we're here. I'll tell you how we cited the place. You're smiling, aren't you?
I'm just,
Let me
ad hoc
finish.
impact is not part of the criteria.
Let me finish. The way we cited the house is we walked the parcel. There's natural drainage. So when you cite a house, it's not just what does it look like from a viewpoint. You've got septic considerations, which I'll get to you. You have natural topography. Our parcel has 2 natural swales, right? They're wet in the winter. The trees are the wet portion of it. The west side of the property, where Brian suggested, right? The guys are all about visual. That's it. We're building a home. This is a home that's going to last 20, 30, 40 years. It's got to be built in the right spot. We thought we had a nice spot for it. And we brought out a guy named Tony DeHart. He cited 500 homes, DeHart Construction. You can look him up. He came out, saw where we were thinking of. We were actually thinking a little closer to the trees. He walks out, he looks at it, he looks at the terrain, he walks over, says, this is where your house needs to go. This is where you're going to have the least grading. This is where you're going to have access to power. This is where the drainage is going to go down to the septic field. We staked it out. We walked it. We checked it at sunrise. We checked it at sunset. We checked prevailing winds. We said, okay, this is the spot. We think it's the right house in the right location on this parcel. People have hung up on the 3480 right? This is a moderate sized house. This is not a big house. This is not an apartment building. There's no bowling alleys in it. It is far from a trophy project. Jeff used the phrase compound a couple times. It's one house and an accessory building. An accessory building will park cars and will have a little art studio in it. That's all it is. Those have been angled, in fact, so that when Tom McCall, when you look down, you don't see them. You're looking at the end of them. So I guess the other thing I would say, of course, is the siting has to do with fire safety and the preservation of the trees. So it's hard to sit here and listen to this when we have undertaken to put together what we think is a really solid plan, a well-considered house, not oversized, not trophy, located in the spot on the parcel that is appropriate for the house. It's where the house is supposed to go. Our contractor came out, a guy named Scott Sorensen, said the exact same thing. Looked at what Tony did, came out, they're nodding their heads. So we here have the old timers. The guy came out, Dale Husky is of Husky Road in Mosier came out. They're the ones who consulted with DeHart as well. Nodded. So we've got the old timers telling us, yes, young man, this is where your house ought to go. So that's where we are going to put it. I guess in summary, we think that we have looked at a lot of site plans and therefore put together a strong one. The idea that this one is, if you saw the site plans that we reviewed, this is by far the most complete and most thoughtful site plan of any of the population that we saw. The idea, I think it's going to serve as a role model here, frankly, because we received some role models so that we could prepare ours. And ours is honestly more complete and better. So to summarize and wrap it up, we think we have a reasonably sized house located in the right portion of the parcel. And we've taken every possible step to make it visually subordinate to comply with the national scenic provisions. Thank you very much.
Thank you. Does the Planning Commission have any questions of the applicant or of the applicant?
I do.
Yes, Commissioner McIntyre.
You were going to address the septic system.
Septic, thank you. So there is one area on the parcel that's approved for septic. There's one area. It originally in, I think, 1973, it was perk tested. It is in the portion of the oak grove to the north of the property. The house is sited so that waste will flow down into this. So we brought out Tony DeHart of DeHart Construction. He's the guy that sited the homes. And he installed septic systems. So he's a septic installer. He came out, he walked the property. He brought Dale Husky out with a backhoe. They drove it down there and they dug probably 8 test holes to be sure there was enough soil, to be sure that he thought he could install a septic system and that there would be enough room for the primary field and then space for the secondary field. There has been no mention by anybody of removing oak trees or a requirement to move oak trees, none. In addition, we spoke to Nicole Bailey, yes, she's probably not there anymore, with the 3-county health department over here. What do you think about the septic field? What do you think about the location of the house? She said trees and septic fields don't always go together, but that's the only place you're approved. And so there was no indication that when we applied for a permit for the septic that there would be any issues with them. We also tested out in the open part of the field and there wasn't enough soil there. There was Tony and Dale took the backhoe over and there's about 20 inches of soil directly north of the proposed site. So We know that there's soil there. We tested it with these test holes. And we have no knowledge or any intention to remove a single oak tree. I believe he can just wind it through there. Thanks for asking.
Commissioner McIntyre, did that respond to you?
Yes, thank you.
Okay, thank you. Does the planning commission have any other questions of the applicant?
Yeah, I have one question.
Yes, please,
Um,
Commissioner Hargrave.
Thank you. So regarding the septic system, it's the backup septic system that would be in the Oaks, is that correct?
No, the primary.
The primary. And, you know, I understand you need dirt and I understand that you need it to be downhill, but is there no other location besides being in the Oaks that would be viable?
So I'm not a septic or sanitation expert, of course. We're learning on the job here. We have been told that there is a different method. Pack and fill is what it might be called. Does anybody?
Sand fill, I think, but something like that, yeah.
Where essentially what you do is, and it would be in the area directly north of where the house is proposed to be sited. There is some process by which either sand is brought in, I don't know what I'm talking about. Sand is brought in or fill is brought in. In other words, you create an artificial drain field. So I asked Tony Dehart about this, and he directed me to the trees. So that's really all I know.
Okay, thanks.
Okay, thank you. And I do have a question, if I may. I'm wondering, in terms of, I know that you've said that you've walked the property and you've walked it with several other folks who know about septic. What kind of, what other options have you explored in terms of siting using the natural vegetation and topography? Have you laid out different options that might be able to provide, not divide up the field or somehow meet the requirements in a way that would take advantage of some of the things that the Friends of the Columbia Gorge have outlined?
Well, excuse me. Of course, we know from 20 years ago where they want us to put the house. Their first choice is in the northwest corner at the bottom of the funnel, right? Taking out 20 years ago, this is where you were.
We're not there today.
Your buddy Nathan Baker. Second choice was in the middle of the trees. Third choice was at the edge of the trees, and they just sort of going up that side. So we believe the house is sited in the right spot, given all of the competing requirements for siting a home, right? Not just existing vegetation. That's one of about a dozen requirements. We need access to power. We need access to water. We need to use the natural topography and the natural drainage. We need to provide with enough visual subordination, which we think we've done with the backdrop. We have to design the house in a way the low 15-foot roof. So we believe that the house is in the right location and that we've designed it in a way and sited it in a way, the dwelling and the accessory structure, that we achieve visual subordination without putting the house in the wrong spot. That's really it. We really are resisting this time around putting the house in the wrong spot to please los amigos.
I guess what I'm asking is, if there's a regulation, if there's something that the spirit and the letter of the burden of proof, you have to meet that. And the burden of proof is not putting the house in the right place. It's meeting the burden of proof and then putting the house in the right place, given everything else. Do you feel you've met that burden of proof? And what evidence do you have that you've met it?
Okay, so I'm sorry, but you're sounding like an attorney, and I don't know exactly how to answer that question. I mean, we have designed and cited a house. I mean, I don't understand the burden of proof question. I'm sorry.
Well, I guess that'll come through this process. We'll come to that, I guess, and it will. The commission will, having heard all the evidence, will decide whether that proof has been met. Okay, thank you. Does the commission have any other questions? Okay, hearing none, I'm going to move on to the next piece. Are there any individuals with party status or members of the audience who wish to speak in favor of the appeal? And if so, please unmute yourself. State your name for the record and your address, and provide any comments you may have.
Oh, thank you. Sheila Dooley, 3300 Vensel Road, Mosier. And it appears to me that they didn't really look at alternative sites for the septic drain field. And if the septic drain field results in removal of Oregon white oak, despite the availability of alternative sites, that would be in violation of the NSA Ludo 14.100H. In the staff report, it stated that if additional trees needed to be removed, this is for the septic drain field, they'd be bound by the condition requiring replacement. But this would mean planning to replace the removed oak trees at a 3-to-1 ratio. And that's a very long-term proposition that won't see results as visual screening for a very long time. The oak trees on the property are 300 to 400 years old, according to the staff report. They're very slow growing. When I moved here about 50 years ago, oak trees referred to as scrub oak in the Mosier area. And many of them are scrawny little trees. Now, some of these same trees are growing into somewhat large oaks, but they still have a long ways to go. It's a very slow process. Oregon white oaks are valuable wildlife habitat trees. The Mosier area and this part of the gorge contain a unique pine oak habitat. The greatest threat to these oak trees is from development. The value of these trees is not appreciated or known to people in general, and more public education is needed. In the letter from Jeremy Thompson, the district wildlife biologist, he stated that ODFW has requested that to the extent possible, no Oregon white oaks be removed, as they're an important component of the habitat in this area. Thank you.
Thank you, Ms. Dooley. I appreciate that. Is there any other individual who would like to, or party who would like to give testimony? Okay, thank you. Hearing none, are there any individuals with party status or members of the audience who wish to speak in opposition of the appeal? If so, please unmute yourself, state your name and your address for the record, and please provide your testimony. I'm sorry, I missed something about Ms. Dooley's testimony. Does the commission have any questions? Okay, hearing none, then I will move to anyone who wishes to speak in opposition of the appeal.
And Chair, we do not have anybody registered or anybody else on the call.
Very good. Thank you very much. All right, very good. Does the appellant wish to rebut any of the testimony by Miss Dooley?
Wait, but Ms. Dooley?
You can rebut.
You can rebut.
Yeah, so I wanted to mention one thing. The development across the street was brought up by the applicant. And while it is on a neighboring parcel, it's really an apples to oranges comparison. There was very little vegetation on that site to take advantage of. No oak forest on the parcel, just a few ponderosas in one small area. So siting is less dependent on using the existing vegetation to achieve visual subordinates. Also, the sizes of the buildings are radically different. On the one across the street, the dwelling is proposed at 2,030 square feet versus 3,480 for this proposal. The accessory structure was proposed for 502 square feet versus 1,500 square feet for this proposal. And totaling it all up, it's basically 2,500 square feet versus 5,000 square feet. So basically half the building footprint. And so I wanted to mention that. Jeff, do you have anything?
Yeah, Jeff Kleinman again. We understand the points that the applicant made about why they want the house to be this size, why they want to do the things they want to do, the way they want to do them.
Mr.
But
Kleinman,
yes,
I'm going to interrupt because this was regarding whether there was any comment on the testimony that was previously given. I believe that's right, Director, from Ms. Dooley.
They can rebut Mr. Curry's testimony as well, Chair.
Okay, because I know the next question is if there's any further testimony from anyone about anything that we've discussed before we've closed. So if we're at that point, I just want to recognize that's where we are. Thank you. Please
thank
proceed,
you.
Mr. Clement.
Thank you, Chair Willis. It was my understanding there was no one else who wanted to speak. So just very briefly, this is what is called a self-imposed hardship. We understand that the applicant has family needs that it wants to meet. That's a given, and nobody, is poking at that. But the problem is that they purchased property in the National Scenic Area, and there are constraints that have to be met. There's a burden of proof that has to be met. There are points of compliance like whether oaks will be removed or killed due to the siting of the drain field, and those cannot be deferred. So for all the reasons that I stated, that Mr. McCoy stated, and that Mr. Bainson stated, the applicant just has not met its burden. And the burden of proof doesn't change based upon your personal needs. The size of your family, the fact that you're likely to have grandchildren who want to visit, you want to have family reunions on this lovely property, you still have to meet the criteria. And you are looking at an outsized house, regardless of any arguments to the contrary. If you look at the house and the accessory structure, and if you treated them as two-story buildings, you'd be looking at 10,000 square feet. 5,000 square feet on the ground floor is large. 1,500 or so square feet for the accessory structure is not a tiny art studio. The criteria, the requirements, the burden of proof are what they are, whether they're difficult for the applicant or not. And the burden simply has not been met in this case. Thank you.
Thank you. Is there any other party that wishes to provide testimony before the record is closed?
Chair Willis, if I can add, not by way of testimony, but just as a reminder that we did request that the record be held open before the Planning Commission deliberates and makes a decision.
Yes, noted. Thank you. All right. Well, if there's no further testimony and no request that the record remain open other than the 7 days that has been requested, and we have made note of that per ORS 197.7636A. The public hearing is closed and the Planning Commission will enter into deliberation. So this is for the Planning Commissioners only. You may ask questions of staff. Clarifying questions may be made to staff and the appellant. No new information may be added unless the hearing is continued. And a specific request is made to staff to obtain additional information for the Planning Commissioner's consideration. So I open it up now to deliberation for the Planning Commission. Commissioners, yes. Commissioner McIntyre, do you have comments?
I have a question for Daniel. Does anything that the Friends representative said today change any of your recommendations and findings?
Well, Commissioner, I wasn't aware of the official policy with regarding, I believe it's 14100C. And so that is an interesting methodology for analysis that I wasn't aware of, the staff wasn't aware of. So if it's an official policy, that could very well alter staff's analysis.
I'd like to ask a follow-up question as well. And this is to staff generally and the director, or maybe just something to be taken away to get more information about. Two decisions were noted here, Bacchus and Eagle Ridge, and that was overturning approvals due to lack of information and not meeting the burden of proof. I'm wondering what parallels there are to this particular appeal. I am wondering about it. I find it compelling that it's true that the decision is not to be made on some of the factors that, while legitimate, while to be taken into consideration as an owner of the property, as an architect, as somebody who's looking at the site, for sure. I would just want to acknowledge those are all legitimate, but in terms of trying to, for the purposes of this appeal, as I understand it, this is not based on a lot of the factors that the appellant mentioned. It really is based on factors that have been brought up regarding vegetation, topography, and some of the other factors that we've listened to. I am wondering about those decisions. I'd like to find out more about it and whether it influences what staff has recommended. The floor is also open for commissioners for other questions that may come up for any of the other commissioners on this call.
Well, I have a question for Daniel. It's pretty broad. I was just curious, Daniel, based on what you've heard in the meeting today. For example, the reference to the official policy you weren't aware of. So based on everything you have learned in the meeting today, would it change your recommendation?
That's an interesting question, Commissioner. One of the notes that I wrote down was that how will moving the dwelling further to the southwest make the dwelling or the development in general more visually subordinate as opposed to where it's at or where it's placed currently. And again, I'm not a landscape architect. That's an interesting question. And again, I didn't get an opportunity to read what Mr. McCoy provided to the commission during the hearing or right before the hearing. So I don't know if the landscape architect has actually addressed that issue as to, I was able to kind of breeze through the submitted information, as well as look at the alternative proposals to where the house and the garage should be situated. I wasn't able to read what is fairly, it's at least 2 pages worth of information with regards to how moving the structure would be or would make the particular development more visually subordinate as opposed to where it's located right now.
Can I ask a follow-up question, Chairman, or whoever?
Of course, please.
Thanks. So based on what you've learned today, do you think that, because I've worked with you for a long time and I know that you're very thorough, and I've looked at the work in this report recommendation, and it's very logical and complete. But some new information has been introduced, and I'm not an expert, I'm not a professional, so I can't really judge how new or how relevant the information is, frankly. But my question for you is, based on what you've heard today, do you think any new information has been introduced that might represent grounds for a successful appeal to LUBA?
Well, Commissioner, this wouldn't be appealed to LUBA. It would be
Not
appealed-
directly, but I was just asking from their perspective.
Well, it would be appealed to the Board of County Commissioners and then appealed to the Gorge Commission.
Oh, thanks. You're right. I'm sorry.
I'd
Yeah.
first like to say that, I mean, this whole thing's a public process, and both parties had ample amount of time to introduce this type of analysis prior to the hearing, prior to the Planning Commission packet, prior to the slides being reviewed by staff. So given what the testimony that I've heard and the very brief amount of time I've had to actually analyze this information, I don't necessarily know if it would change my current recommendation. And again, I haven't been able to read the Bacchus decision or the Eagle Ridge decision.
Right.
So what I will say is that I'm going to assert that it's official Gorge Commission policy that's been provided. I think I've seen a year of 2020, I believe. That could very well alter my recommendations with regards to cumulative impact as well, but the compatibility, the height, the size, the mass.
I'd just like to make an observation here, and this is Chair Willis. What strikes me about this conversation, the complexity of what we're trying to consider. We've heard a lot of information. The packet was very comprehensive. It was very long and comprehensive. There is new information coming here. There's some information we simply haven't had a chance to review, it seems that all things considered, when you're trying to make a decision, the best thing to do is to make sure all things are considered and that we actually have enough information to make a good decision. And that when we're talking about information in terms of a burden of proof, it's like there is a standard for a reason, because that was set with something in mind, and the question is, have all the right questions been asked? Has all the right information been gathered? And basically saying, knowing that this is where the house is supposed to go, or that in terms of the septic piece, well, there was no mention of removing oak trees, but that doesn't mean, as a matter of fact, that we've explicitly asked, will there be? This isn't something about anyone involved in this process. It's just an issue of, do we have all the facts? And that's the question in my mind. And Daniel, you did get new information. So that's what's going on in my mind, commissioners, is do we have enough information to make a well-considered decision here or not?
Do you want a discussion on that, or are we at a point of
Yes.
deliberation, or?
I don't know. Do we want a discussion? I don't need to discuss it further. Do the rest of the commissioners need to discuss it further? Because our next step is to make a motion. And we have several choices on a motion to be made.
I would make a motion.
Okay,
Are you ready for a motion?
I believe so. Are we ready for, is there any commissioner who would like to speak up at this moment to say that we still need to deliberate? Speak now. And otherwise we'll move to a motion.
Well,
Okay.
and deliberation is, follows the motion, so no opportunity lost.
Yes, right. Please, Commissioner McIntyre. Yes, we have 4 options for a motion.
I move to approve the request with the amended conditions and findings, including the updated conditions and findings in the report today.
Sorry, Lynn, could you repeat that? It broke up here for me.
I move to approve the request with the amended conditions and findings, including the additional amended conditions and findings stated today by Daniel.
Okay, and so we deliberate this motion, I believe.
You need a.
Well, it's got to be
second.
seconded.
Okay, do I hear a second? Okay, not hearing a second. I need a little bit of process help here, but I believe that then the motion is not seconded and we're not moving to discussion on it.
Yeah, that's correct. I'd
Okay.
like to make a motion.
Yes,
I would
Commissioner
make the
Hargreaves.
same motion that Lynn made, which is to approve the recommendation with the updated conditions. Is that correct, Lynn?
Yeah, to approve the request with including the updated conditions and findings.
So when you say approve the request, we're upholding the director's decision?
Yes.
Okay, so my motion would be the same as Lynn's, but with a couple additions. And I wanted to preface it by saying that, just kind of explaining where I'm coming from, because I do think that oak habitat is extremely important. I think we all know that. But as someone who's lived here a long time and has a lot of oaks, I've really come to appreciate how important they are, especially after a fire that I've just gone through. I also feel that visual subordination is extremely important, not only from key viewpoints, but in general. It's the gorge, that's an important, looking natural is an important aspect of what I think we all want.
So Commissioner Hargreaves, I just want to clarify your motion. So you're.
I was going to rephrase it here succinctly. So my motion would be to approve the recommendation with the updated conditions and to add a condition to relocate the drain field out of the oak trees. There's only an acre of oak trees there. So I would add that condition. That's my motion.
Do I hear a second?
Lynn?
Oh, sure. Just for discussion, yeah.
Okay, so what I'm hearing is the motion from Commissioner Hargrave to approve the request with the amended conditions and findings and adding a condition to move the septic field. Did you say, Commissioner Hargrave, the additional condition being to move the septic field to?
To move it out of the oaks, there's approximately an acre of oaks. It seemed well defined. I've been looking on the map here during the discussion. And so, yeah, to move it out of that section of oaks.
Okay. And Commissioner McIntyre has seconded. Let's have a discussion then. We'll move to that. Go ahead, Commissioner McIntyre.
My concern is that if that is the best location physically for a drain field, then has the best soil conditions for a drain field and the best soil depth. And that's what the people that know these things are saying, then are we not creating an additional problem by trying to say they don't know what they're talking about and the drain field needs to be located somewhere that is less suitable for a drain field?
Could I respond to that, Chairman?
Yes, we're in
Chairperson?
discussion.
Yeah, sorry, I'm just being formal. So
Yes,
Lynn,
thank
my
you.
thinking on that is that I absolutely respect Tony and Dale. I think Dale Kennedy is the person that was actually referred to there, not Dale Husky. I respect their opinions. And if you ask a septic person, where's the best place to locate a septic system, they will give you an answer from that perspective. But if you try to strike a balance with a forest person and a septic person, you might find a different location. I'm recommending that we do strike that balance. And I'm not doubting that that is the best location for the septic. Probably that's where the deepest soil is. And that's why the trees prefer it. And that's why the septic would be most successful there. But there are other technologies, as the applicant made reference to. And I think that that's a better balance for the concerns that have been raised in this appeal.
I agree. And I know if there are alternative options, they need to be explored, and the burden of proof is on the applicant. It is on the applicant to make sure that we have enough alternatives. So I would agree with that. But I'm also concerned about other issues that have been raised and whether the burden of proof has been met on that. And I really feel, as a matter of that our role is to make sure that the burden of proof has been met here. And I would ask that we are in discussion now. We haven't come to a vote, but in order to come to a vote, I don't feel like that's taking care of enough. It's addressing enough of the issues that have been raised. I would like to see the applicant address specifically the issues that have been raised so that I feel satisfied. And I don't know if we as commissioners feel satisfied that everything has been considered and they have met that burden of proof for the decision we're trying to make about these particular ordinances.
Can I comment on that? Kate?
Yes.
Yeah, of course. For each issue that's been raised, we need to satisfy ourselves that the response meets the burden of proof. And to do that, I look fundamentally to Daniel's document, which does enumerate the response to each issue that was raised. There's been a lot of discussion in this meeting, and that's very complex, as you said earlier. However, I still look back to that document, which does specifically address each point. And to me, other than the location of the septic, each point seemed to be adequately addressed, and the primary complaint did seem to be around the size of the dwelling. You know, is it sufficiently visually subordinate from McCall Park? Well, it's 15 feet tall to the top of the roof. So I look to that document as the enumeration in the body of proof.
Okay, fair enough. Commissioner McIntyre, further discussion?
No, I said what I had to say, and you have a motion in a second.
Yes, we do. Okay, and so now we're moving to vote. Let's go ahead and vote. All in favor of this motion? Director, do we have it well enough stated for the record, and then we can move to vote?
Yes, Chair, thank you.
Okay, great. All right, I move to a vote. All in favor of this motion, please say aye.
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 All right, thank you. All opposed, please say nay. Nay. And then if we have three and the vote carries, is that right?
That's correct.
Okay, great. So we are now directing staff that the vote carries. And I believe we are at the conclusion of the hearing. So now the next steps. There will be a decision of there's a decision of the Planning Commission. This vote has been carried as stated. There is an appeal process to the Board of Commissioners. Notice of the decision would be mailed by Thursday, October 6, 2022. The appeal period is 15 days from the date of mailing and will expire at 4 p.m. on Tuesday, October 21st, 2022, according to ORS 197.830. If no appeal is filed, the decision of the Planning Commission in this matter shall be final. And I would like a motion to adjourn.
I move we adjourn.
Do I hear a second?
Sorry, there's other business.
Well, you need to close. You need
Wait
to
a minute,
close-
we have a motion on the floor.
You need to close the hearing first.
The hearing was
Is it
closed.
closed?
Yeah.
Okay.
I'm sorry, I'm following the script. What am I missing?
The director's report.
I do have a director's report.
Director's report, please. Do we close this out while we have a motion in, before we adjourn, we've motioned for the.
I withdraw the motion.
For the hearing. Let's go ahead and hear the director's report and then we'll motion to adjourn.
Thank you. So I wanted to give some updates to the commission. First, we are winding down work on the community wildfire protection plan with an estimated date in front of the Board of County Commissioners for December. We'll have the draft available for public comment in October. And if you're paying attention to some of the wildfire regulations going on with state agencies, we believe our CWPP is in lockstep with the requirements that are coming out, building codes, Office of State Fire Marshal, and DLCD and ODF. So this body will not be hearing that document, but I do encourage you guys to engage and encourage your friends and neighbors to engage in that update. I'm happy to send along a notice when the draft is available for public comment. I wanted to just quickly, since a few of you were not in attendance at the 20th hearing, let you know that the Planning Commission did advance the Land Use and Development Ordinance update to the Board of County Commissioners. The first hearing for that will be on October 19th. There were some small modifications made to the existing drafts. Basically, all optional uses that are proposed are advancing as recommended to the Board of County Commissioners. I also wanted to share that again, next year, it's likely the Land Use and Development Ordinance update will be heard again by this body in September. I also wanted to let the Planning Commission know we have a new code compliance officer, Ted Palmer, and we are working to update that ordinance specifically with an eye to increase opportunities for citations process. The other thing I think interesting to note is that our new long-range planner, who is a part-time position, is predominantly focused on a transportation equity project. We'll be looking at some population seasonal workers and also people in poverty to understand their transportation needs, and particularly how we may coordinate with them to connect to the fixed route transit service that is now extended down in Tamaulipas, as well as address any other concerns that they have, and particularly look at evacuation and fire response as it's coming across with the Senate Bill 762 work. Finally, I wanted to let this body know that after a lot of deliberation on the department, we are going to be trialing starting January 1 using a hearings examiner for these types of cases. So the Planning Commission will just be hearing legislative matters for 2023. And all quasi-judicial things like appeals will be going directly to a hearings examiner. We have a couple contracts that we're looking at exploring and talking to the Board of County Commissioners for their approval with. So I'll keep you guys in the loop, but that will have a direct impact on this body. And it means that it will dramatically reduce the amount of meetings that you need to attend on behalf of the Planning Commission for Wasco County. So next year, it's likely that you may only have to do 1 or 2 hearings. And there's lots of reasons why we're going to be trialing this next year. One of the main ones is that it is really difficult. It's been very difficult over the last several years to get a quorum consistently. And that can create some kind of undue delays on the part of applications. And also, we do have concerns about the increasing amount of litigiousness, not necessarily in Wasco County, but in neighboring counties. And the hearings examiners typically are attorneys by trade. And so we think it's going to offer the county additional protections in administering decisions moving forward. So I'm happy to answer any specific questions you have about anything I presented, but that's what I got for now. Thank you, Chair.
Thank you. Good news. Appreciate all of that. Okay, now we are ready for a motion to adjourn, I believe.
I had a question.
Commissioner McIntyre has a question.
Yes, please.
So the hearings examiner, they are the final arbiter of appeals, or they are acting on behalf of the commission?
They become the decision-making body at the Planning Commission level.
Okay.
So the Board of County Commissioners would still serve as an appellate body.
Okay, thank you.
Okay, so it's bifurcated, then legislative will be to this body, and then it would go, okay, got it. Okay, I don't want to, if there are any other questions, any other concerns, questions of the director, Marcus, Commissioner Swift, Commissioner Hargrave.
I think I'm lights out.
Okay. Do I have a motion to adjourn?
Move.
Okay, I second. Can I second?
Second, third.
Okay, can we take a vote? All in favor?
Aye.
Aye. Aye.
Thank
Any
you,
opposed?
Commissioners. I appreciate it. I know this was an extra long hearing, so thank you for your attendance tonight and your participation. It's much appreciated.